okay? If we don't get started, you're not going to get away on time, and then you're all going to get parking tickets and you're going to blame us. So, yeah, I can't. Right, thank you very much for coming, everyone. I really hope that you're here for the MCA and Doles refresher, Pan Dorset. So we've got colleagues from Dorset and some BCP, and we've also got some doctors here. So really pleased to have you all. We've got a really packed lineup. Not sure that we're going to get through everything, but we'll give it a go. So I'm Sue Farmer, manager of the MCA team in Dorset. Our clicker's not working, so we're going to have to use Rhiannon as our manual clicker at the back. So can we have the next slide, please, Rhiannon? And I'll just run through some of the housekeeping. It is being recorded, so there will be an opportunity to share it with colleagues if you so wish. Obviously, the sort of standard stuff, if you could keep your mobiles on silent, and if you need to take a call, if you could step outside, that would be great. As far as I'm aware, we're not expecting a fire alarm, so we would leave by that door or that door, depending on where the fire is, and muster in the car park. Obviously, it's a no smoking building, so you'll need to step outside to smoke. We've got a break planned in the middle of the morning. If you've already got a cup of tea or coffee, if you could hang on to the cup, we'd be really, really grateful, because our lovely admin team are playing tea lady for the day, so they don't have to do too much washing up. Happy for you to ask questions as you go along. We'd rather it's a little bit more interactive, but if we start running out of time, we might need to pick up a bit of speed. And then at the end, you'll be asked for feedback, which we always appreciate, to make sure that we're getting it right and tweak it and change things. And once you've done that, you'll get a certificate to say that you've been here. And presumably we can send out a recording to everybody. Cool. Can I have the next slide, please, Rihanna? So we've got 4 sections today. So Tilly's going to start with a much more in-depth look at fluctuating capacity. And then Ben Holt and Michelle Hughes, from ICSD, have come to give us a little bit of talk about the work of ICSD. And I do think we could be a bit of a lion's den of social workers, so be kind to them, please. She doesn't care. I'm going to do a quick case law update. There's not really that much rocking our world at the moment, so just a brief case law update. And then Gemma Knowles is doing Stokes. Sorry. She's our principal OT. She's going to look at the use of equipment and restrictive equipment and how that fits with Doles, which we think is probably quite overdue. So, thank you very much for coming, and I will hand you over to Tilly.
Oh, this is a bit scary. There's a lot more of you than I was thinking. So I'm Tilly Baden. I'm the Assistant Team Manager in the MCA team for Dorset Council. So I'm going to talk to you a little bit about fluctuating capacity. For those of you that have come on the masterclass, you might have already seen some of these slides, but I'm going to try and link this into the context of Doles. So it will apply to your wider health and social care practice, but we're a Doles Forum today, so we will bring it back to Doles. Next slide, please. So I like to start off by just having a think about the reasons behind fluctuating capacity. Because on a lot of referral forms, it's quite common to get the sentence, person has fluctuating capacity, full stop. Well, what does that actually mean? And how are we going to relate that into the support that we give to that person? So there are loads of different reasons why someone's capacity might fluctuate. So to start off with, it could be a medical condition. Infections is a really common one. People's pain, sometimes actual conditions such as Parkinson's, Huntington's, so many more out there. We have things like constipation as well, diet, food and fluids, sugar levels, all sorts of things that might be going on for someone medically. Certain medications or treatments might cause someone's capacity to fluctuate. So the obvious ones, sedative medications. If you've just given someone a sedative, now is not probably the best time to speak to them. But it can also be non-prescribed medications as well. So we think about substances, alcohol. Those can also cause someone's capacity to fluctuate as well. Then we've got mental health conditions. So schizophrenia, bipolar, all of the different mental health conditions that we have. Really common then for people with dementia as well. We see a lot of sundowning in the evening, which can also cause someone's ability to make decisions to fluctuate. Then we've got environmental factors as well. So stress is a really big one, and fatigue. If you're talking to someone, they've just woken up, or they've got their eyes closed and they've had a really difficult night, then maybe not the best time to go and speak to them. And then finally, we've also got external influences, and those can be both positive and negative. We often think about them being negative, but it might be sort of positive as well, because people want to please their loved ones, do the right thing for their loved ones, but that might make someone's capacity fluctuate. So we would just need to think about the reasons why behind someone's fluctuating capacity to see if we can optimize it. Is there something that we can put in place to reduce that fluctuations before we move forward? Next slide, please. The material time dilemma, one of my favorites that we get caught up in all the time. So we talk about capacity assessments being decision and time specific, but somehow this has got mistranslated and this artificial rule has been created that material time only means the conversation that you're having with someone, and as soon as you step away, that time's gone. Well, that's not true, because a lot of the decisions that we're making, someone has to be able to have some sort of performative element outside of the conversation. So when we're talking about decision and time specific is going to change depending on the nature of the decision. Next slide, please. So our starting point then. So when you've seen someone and their referral says, person has fluctuating capacity, well, what are you going to do then? So what constitutes the material time will depend on the type of decision that we're needing to make. So one-off decisions, these are the most straightforward ones. They're the ones that someone needs to make just in the moment. So it might be making a lasting power of attorney, consenting to a COVID vaccination, something that needs to be there in the moment and then it's done. But most of our decisions that we make are ongoing, repeated and performative in their nature. And that means that the application of the relevant information needs to take place outside of that conversation that you're having with that person. So some of the examples then of continuous decisions that we might be asked to assess someone's capacity around. These are the obvious ones: care arrangements, finances, medication, sex, conducting litigation, internet, social media, dolls. I didn't put that one up there specifically, but yes, consent to admission and treatment in hospital, discharge arrangements, deprivation of liberty. These are ongoing performative decisions where the information has to apply outside of that conversation that you're having with that person. So what do we do then? Well, like I said, the one-off decisions are the most straightforward. So your first question is it urgent? Can it wait? If someone's on the floor and they've just had a fall and they're bleeding, it's not going to be able to wait. You're going to have to do your best guess of capacity and make a decision there and then. But for some decisions, actually it can be put off. If you're going out to look at someone's power of attorney documentation, well, actually, if you get there and they're half asleep, or they've just had some sedative medication, or they're having a bout of infections or something like that, you're going to delay it and then go back. It's the repeated continuous decisions that we find the most difficult as practitioners, but case law has now given us a sort of a roadmap through how to deal with these decisions. We have two approaches: the longitudinal approach and the anticipatory approach. Next slide, please, Rhiannon. So don't get too worked up on the names. I'm going to go through the case law that sits behind these, but I promise you it will make sense. Bear with me. So the longitudinal approach was sort of set out in the PWK case back in 2019, and this is where the coined phrase longitudinal view first came into fruition. It's not a new concept, it was based on previous case law, but it seemed to be that 2019 was our year where we kind of got fluctuating capacity for the first time. And then it was also cited in the CDM case, which we'll go through. With the anticipatory approach way how to deal with fluctuating capacity, this was first developed in the DN case and cited in the CD case as well. The problem is when judgments are released is that they're not always released on the moment when the case law was actually decided by the judge. So these are all kind of around about the same time. But fortunately, even though these are in different parts of the countries and the judges are different in the cases, they all kind of came up with the same thing, which is really helpful. So our first case then, we've got the PWK case. So this is about a 24-year-old man who's diagnosed with autism, a mild learning disability and anxiety. So this chap, his anxiety would become so severe at very unpredictable times. There were loads of different triggers. It was really difficult for people to work out how his anxiety was impacting on his daily life. He lived in a supported living placement, and he was Section 117 funded, and he had 2-to-1 supervision, which kind of gives you the level of PWK's needs. It came to court as a deprivation of liberty in the community case, but there were also some other decisions that the court were asked to look at, including care, accommodation, contact with others, internet use, and financial affairs. Next slide, please. So the judge in this case, Sir Mark Headley, said that contact, accommodation, care and internet use and financial decisions, these are all repeated continuous decisions. And Sir Mark Headley was the judge that sat on the case, the ABC XYZ case back from 2012, which you might remember as being sort of foundation case of where we look at management of financial affairs. And he said, in that case, back in the ABC case, he said, management of finances is not just a one-off thing. You can't say, well, I understand what's in my bank account. I understand I can read a bank statement, full stop, then the person has or hasn't got capacity. Actually, you have to be able to use lots of information all the time on a repeated nature to be able to manage your finances. And the judge said, well, that's kind of like it is in care as well. Because actually, there are so many different parts of a care arrangements decision that you need to be able to make those decisions on an ongoing basis. And the court said that because PWK's anxiety is so sort of difficult to predict, difficult to manage, that actually it was having such an enormous impact on his life, he wasn't able to make his decisions on that ongoing and repeated nature. And the judge said that this is taking a longitudinal view of capacity. So the other case that we kind of look at all the time when we talk about longitudinal view is the CDM case. So you might remember this as being the diabetes management case. So CDM was a 64-year-old woman with personality disorder and diabetes. And this case came back to court several times. We've got quite a few judgments in relation to this lady. But in this particular reference, the judge said that because diabetes management involves so many different micro decisions, so you've got to know your blood sugars, you've got to be able to adjust your diet, you need to be able to know when to take medication, go into hospital sometimes. There were so many different elements of diabetes management. He said, well, that's a macro decision made up of a series of micro decisions. And what we can't have is someone having capacity for certain micro decisions and not the others, and then having an unworkable care plan. Because what are those carers going to do in the moment? Do they give medication? Do they not? Do they say that she can't have that piece of cake or not? They need to know what they're going to do. And so the judge said, well, it's still decision specific if we say it's a macro decision made up of a series of micro decisions. And yes, we can maximise her decision making within that, but we're going to do it under the framework of best interests. So that's kind of the view that the judge took in this case, and it kind of fits in with the longitudinal approach. So the judge said, Justice Newton said, I acknowledge, as do the experts, that there may be occasions when CDM has capacity to make the micro decisions in respect of her diabetes, but there are also occasions when she doesn't. Her capacity doesn't fluctuate, fluctuate, but if we look at the matter sort of logically, legally and practicably, it's a macro decision, and therefore she lacks capacity to make the macro decisions, so the issue of fluctuating capacity simply then doesn't arise. Makes it a bit more easy for us to work with. So the key points of taking a longitudinal view then, we need to assess P's actions and behaviours over time. We might have to think about what percentage they do have capacity versus that they don't for that decision. When do they get anxious? What's impacting on their, what are the reasons, going back to that first slide, what is it that's causing their capacity to fluctuate? Are there more times than not when P is able to make that decision? Is it a macro decision that can be broken down into a series of micro decisions? And that's still fitting in with our concept of decisions being decision specific. But it encourages us to be more holistic in our assessments. They are much more than just a snapshot over time for these repeated, ongoing, continuous decisions. And what's coming out in case law at the moment is this concept of not assessing capacity in silos. And what this means is that we have to look at the person's whole situation and make sure that we're not making a conclusion that's incompatible with another area of their life. So, for example, I see this quite a lot where someone might say, well, they lack capacity around their care, has capacity around finances, they're a self-funder, they're refusing to pay for care. Those sorts of things then become incompatible, because what does the worker do on the ground? We have to take into account the relevant information in each of those decisions and make sure that they marry up. And that might need to have a bit more digging and asking some different questions, but we can't have these incompatible decisions. And this was really brought home in the AH case, which you might remember we talked about in, I think this time last year in the last Dorset Forum, when we said that this was some Doles assessors that went out to assess AH after she'd been discharged from hospital. It was a Section 21A challenge. The court had instructed a special psychiatrist to conduct a Section 49 report, and they found that she lacked capacity around her care and treatment. The Doles assessors went out and said, well, no, she's got capacity. Okay, right, well, we're in proceedings. That might be valid, but what happens? AH is objecting to be in a care home. So what does that mean? Is she going home? Did you have that conversation with her around, well, if she goes home without care, she's going to die. That's going to be a really undignified death. You can't just look at that moment about being in the care home in that conversation. If you didn't have those wider conversations with her about the risks of going home, then that's not a defensible assessment. Okay. So the anticipatory approach then. So this came about with DN. It's a really interesting case, actually. I would recommend you reading about it if you read the case citation on Barley. So this is a 25-year-old man with ASD and anxiety. So he had been convicted of several public order offences and was on a 2-year community order with a 2-year mental health treatment requirement. So that's something that comes in from the magistrates' court for a criminal matter. At no point during any of those proceedings had questions been raised about capacity to litigate, fitness to plead, anything like that. He was generally thought to know what he was doing and be able to make his decisions. But sometimes DM would have these meltdowns, and this is the actual term that they used in this case law, where he would then become so dysregulated that in that moment he couldn't make any decisions. He was just completely overwhelmed, shut off, and care staff had to intervene to keep himself and others safe. So the court were a bit stuck, really, with what to do, because initially people had said, well, he's got capacity. And then they said, well, maybe he hasn't. And this is all around care arrangements and deprivation of liberty. And they didn't really know whether there was going to be a dole, whether there had been a community dole in place or not for him. So the judge decided that actually he has got capacity for care and residence, apart from the times when he's in this really obvious meltdown. There was no question about different care staff interpreting that in different ways. It was obvious when he was in a meltdown. And during those times, care staff could intervene to keep him and others safe. That might amount to a deprivation of liberty, because remember, not negligible period of time. Case law is saying that that's anything up to sort of 30 minutes or more. So during those periods of time, care staff can intervene. His care plan involved physical restraint and sedation if needed. That was lawful. The rest of the time, actually, he had capacity to make his decisions, but during those times, they could keep him safe, and the court ordered that that was lawful. And Justice Cobb, in this case, said, "It seems to me that the outcome of an anticipatory declaration provides that proper legal framework for the care team, so ensuring that any of those temporary periods of a deprivation of liberty are duly authorised." So the second case then, again, this is a really interesting case, CD. So CD was a lady that had schizophrenia, paranoid schizophrenia, and she was under Section 3 of the Mental Health Act, and she was having active treatment in hospital for her schizophrenia. But she was also 35 weeks pregnant, and they needed to make some decisions about her birth. Now, initially, when CD was very acutely unwell and psychotic, they said she lacked capacity to make decisions about her birth arrangements. So the trust, quite rightly, took the case to court and said, we need to work out a plan about what we're going to do when she goes into labour. During that time, though, she was still actively having treatment in hospital. She had been prescribed olanzapine, and that seemed to be working, and she had formed some relationships with some of the support workers. And CD was then felt that actually she might have capacity around her birth plan and her obstetric care when she goes into labour. Now, normally, if someone's got capacity to make that decisions, you'd be looking at advanced consent or advanced decisions to refuse treatment, so that the person was in agreement with their birth plan and they could provide consent, so they're not having to sign consent forms when their baby's coming out. But they didn't think that actually CD, they didn't have time to sort of work through those anticipatory decisions. So they said that there's a very real prospect that actually her mental health is going to deteriorate when she goes into labour. And they wanted some sort of order from the court to say that if that happened, that they could perform the necessary medical procedures to keep her safe. And for the baby safe as well. But don't forget that in UK, babies' rights only come once they've actually been born. So we're thinking about the best interest of the mother here. And actually, the judge in this case said, well, let's make an anticipatory and contingent order to say that if she lacks capacity at the time that you need to take urgent medical action, then I will say that it's in her best interest to have the birth plan as the obstetrics consultants had set out. So they called that this was an anticipatory decision, and they said that this would be lawful. So where does that leave us then? Which approach do we actually use? Da, da, da. Well, fortunately, there are two cases that are fairly recent that have given us quite a useful roadmap through. And it's important to remember that both longitudinal and anticipatory approaches both are legally valid, and it is going to depend on the circumstances of the case. But I already know which one I prefer. I prefer the longitudinal view. I think that's more workable for people generally. Not saying I would never use it, but I think certainly in the context of doles, we're most likely to be looking at a longitudinal view of capacity. So PG, this is a case about a 34-year-old woman, moderate learning disability, ASD, and trauma-based mental illnesses with EUPD traits. Quite a cocktail there. So in this case that they said she lacks capacity to litigate and enter into an occupancy agreement, but they agreed that she had capacity to decide where to live. But the dispute was really about her care arrangements and contact with others when she was anxious. And so the court in this case, so it was Justice Leaven, was asked to decide, well, what do we do with her fluctuating capacity? So he said he'd seen the judgments from his predecessors and said, actually, let's take the longitudinal approach in this case. So the anticipatory approach in this case would have been unworkable. It would have been reliant on the individual carers that are on the ground doing the work to work out whether she had capacity or not to then go out, have contact with others, accept care, not accept care. And it was really difficult. These were complex capacity assessments that simply we couldn't ask our carers to do. It would have been too much in the here and now. Because if she's saying, right, I'm going off to meet with that person, I'm going out the door, what are the carers meant to do? Not very easy to work through. So he took the longitudinal view and said, well, actually, she lacks capacity in these areas. We'll have the best interest decision, which maximises her choices, that when she's well, she's able to make those choices, but we're going to do it in the framework of a best interest decision, because then that's more workable for the carers. So if they're concerned, and she's at the front door saying, I need to go out, I'm going to go and meet with so-and-so, then it's not reliant on the carers to make that capacity assessment. They know that they can use those restrictions in place from the best interest decision and stop her going if they're worried about her safety. So I think that's much more workable and straightforward for people. We also have the H case. Again, very complex list of medical conditions, psychological and psychiatric challenges, global developmental delay, ADHD, executive dysfunction, developmental trauma disorder, and possible EUPD. Again, quite a list. So when dysregulated, H's behaviours would present a risk of harm to herself and others. And the others included there was some sexual abuse concerns against children, so quite a risky individual, so to speak. And the court again were asked to consider H's capacity. And they felt that, on balance, that she lacked capacity in these areas. So, fluctuating capacity, do we have a way forward? And I think we do. As I said, both are legally valid options to take. It's going to depend on the individual facts of the case. But the key question here to ask yourself is, what is going to be more workable? We're asking carers that sometimes are maybe coming from an agency, they might not have any knowledge of that person, they might have just stepped in onto shift on that care home, supported living unit, hospital, they might not have any knowledge of the person. How are we ever going to expect them to make these really complex capacity assessments when with potentially no background knowledge about them? So what is going to be more workable and what's going to keep the person safe? So in the context of dolls, I'll bring this back to dolls now. The first thing is, what is the matter? What is it that we're asking you guys as our assessors? What is it that we're assessing when we're talking about the capacity assessment? Well, in short, consent to care arrangements and residence amounting to the deprivation of liberty of the person, which is a bit of a mouthful and quite difficult to explain when you're there trying to talk to the person and explaining why you're there. So that's why we set out the relevant information in our forms. In simple situations, we need the person to understand their current location, so where are they, their care and support needs, their health needs, including their mental disorder, restrictions on their liberty, why they're there, and the care that's being provided to them. There might obviously be other relevant information points that you need to include. It's going to depend on the person. I know we've done quite a few respite assessments recently, so I'm looking at Jane because you did some of them, and Dr. Blunt. That might include then respite, while the impact of then enabling the carer to maintain their caring role, things like that. But those are generally the points that we need to be looking at. So to talk about a little case study, and for those of you who have been to my training before know that I always use Harry Potter names in all of my case studies. Molly is completely made up. I've just literally plucked the situation out of the air, but hopefully one that will feel quite familiar to you. So Molly, she's an 89-year-old lady. She's living in Hogwarts Care Home. She's been diagnosed with Alzheimer's. So you visit her as a DOLS assessor being asked to do capacity assessment. And you see her mid-morning, which is when the care home said that it's okay to go out. She's normally at her best. And she tells you, yes, I know I'm in Hogwarts Care Home. I've been there for 3 months, correctly saying that. She tells you that she's previously living at home, but she had a fall and went into hospital. She tells you that she's frightened of falling, and she agreed to move into the care home. She didn't want to stay at home. She knows that her home is being sold to fund her care. And she correctly tells you that she does need some help. She tells you that she enjoys the activities, she's made some friends, and she says that her daughter visits her every Saturday. All good so far. So Molly understands that she only goes out with a carer or her daughter, so she knows that she doesn't go out on her own. She knows that there's a pressure alarm mat next to her bed, so that if she needs to get up during the night, someone will be alerted to her and come and help. And she knows that she's prescribed some medication for her memory, so memantine. She says that her memory is not what it used to be. She knows she's getting older, and she's got a fairly good understanding of her current circumstances. So based on this, do you think it would be reasonable to conclude that Molly has capacity for her DOLS? Yeah, everyone's nervous. Yes. Yeah, I agree. Based on that information, very limited information, I think that's fairly reasonable.
You need more information.
Of course. Hold that thought. You might have to click this mod. So, what Molly didn't tell you is that from about 4 p.m. till 10 p.m, roughly, every day, her memory and cognition deteriorates. She forgets where she is. She thinks she needs to go out and collect her daughter from school. She attempts to leave. She becomes aggressive towards the carer who stop her from going out. And she becomes disorientated and confused. She's banging the door. She's attempting to get out. Molly, in this conversation, doesn't recall any of this happening. She denies that she's ever becomes distressed or aggressive. She says, I'm fine. I love it at Hogwarts. It's brilliant. What more could I want? Okay. Has this changed your view on capacity? Possibly, yes. And could the anticipatory or longitudinal approach to fluctuating capacity be used in this situation? Possibly, yes. And does Molly need a DOLS? Yes. Yes! Please say yes. Yeah, I think it would be reasonable to say in this circumstance, Molly does probably need a DOLS in place. We could look for Molly as to whether she understood that during that period that's fairly predictable every day between 4 and 10 that she might need some sort of restrictive interventions to stop her going. But the issue is that she doesn't recall that this happening. If Molly said, yeah, you know what, I get really confused in the evenings, I know that I need some carers to stop me, you know what, I agree to it. They can keep me in, I agree to them giving me some PRM medication. I know that my daughter is an adult now, she doesn't need collecting from school. I know that this happens, I agree to it. Well, that's advanced consent, and that would be fine. The courts have agreed that we can use that. But to give her advanced consent, she needs to know that it's happening, and she needs to have a bit more of that in-depth understanding about what's going on for her. And if she doesn't, I think it would be quite right then to take that longitudinal approach and say she doesn't understand the extent of her care needs and she doesn't understand the care arrangements that are in place. Because to know about her care needs, she'd need to know that the carers are stopping her from going out. And if she doesn't know that, she's probably going to lack capacity. And in this situation, I think the anticipatory approach wouldn't really work. We have dolls for care homes and hospitals that take into account, their whole 24-hour periods. And actually, Molly might have capacity up until 4 p.m, and then, roughly, and then sundowns, and then she regains capacity later on. She might do that. So you might say, well, an anticipatory view could be used, but then are you going to put that through as a dolls? That would probably then need to go to court as a welfare order. No access to legal aid. Molly might have to fund her own legal fees, particularly if she's selling a house. We know she's got capital. Are we going to put Molly all through that just for those 6 hours a day when actually a dolls might be more workable? And then what happens if Molly at 2 o'clock goes up and says, to the carer, I want to go to the shops now. I'm off out. And the carer's thinking, well, what if she's not back by 4? Then what? Am I going to go out after her? What if she becomes confused when she's out and about and then she becomes lost and doesn't know where she is? I know that it's likely that she's going to sundown in the evenings. So am I going to stop her at 2? That then becomes really difficult for the carers to understand. It would be easier to put the dolls in place, which is then allowing the carers to make that judgment call. There might be times that she can go out, but there might not be. The dolls is going to give her that safety net framework, which is the purpose of dolls. I can't take credit for this model. This comes from Neil Allen at 39 Essex Chambers. But he talks about the 3D capacity assessment, and I think this is a really helpful model for us all to use. Because actually, a capacity assessment is like a jigsaw puzzle. We can't just look at one little snapshot and think that that's job done. We've got to be looking at the 3D model of that person's life. So we absolutely need to speak to the person, fundamentally. But we also need to consult with others. We need to know that background information, and we need to look at that real-world evidence. What's going on for that person during their life? How are we going to fit that into our capacity assessment and look at the person's situation holistically? So there's kind of that 3-part to your capacity assessment, and once you've looked at all 3, then I'll say that's a defensible assessment. If you're missing a piece, perhaps not so defensible. Sorry, Rihanna, I think you have to click individually. I thought I'd have the clicker, but sorry. So key takeaways then from this. Always ask yourself, what is workable? We have some brilliant care staff out there, but we also know that we have some not so great care staff. And whilst we have to kind of look at the lowest level of skill set when we're working with someone, because if 99% of carers are getting it right, but there's one carer that then gets it wrong, we're potentially leaving the person at risk. So what is workable for that care team? Person's got to be able to retain the relevant information outside of the conversation. I see sometimes some capacity assessments where professionals have gone up to speak to someone on a hospital ward and the person's gone, oh yes, of course, I know where I'm in hospital, I know where I'm there, I know that I need treatment, and I know that I'm going to need some help on discharge. The assessors go, great, they've got capacity, dole's not needed, or mental health act not needed, that's it. And then 5 minutes later, after they've left, that person's then banging at the door saying, get me out of here, I don't know where I am, I need to go and collect my family member. That's not taking into account that 3D holistic assessment. We need to piece all of those 3 elements together to have a defensible assessment. And I always ask then, does the person know that their memory or their cognition or their whatever it is that their mental disorder is, do they know that that's a thing? Do they know that things fluctuate? Are they able to account for that? Because if they are, they may have capacity. But if they can't, that's a pretty strong indication that they probably don't have capacity around that decision. And I know I used to fall into this trap because I used to love going out and seeing the person first before doing much background information. But I've certainly changed the way how I do my DOLS assessments now. Actually, we need that background information because we need to be able to check out what that person is saying to us. Because if they say, oh yes, of course, I pop to the shops, I go out and I can shower and I take my medication, I do all of this, yet they've been cared for in bed. They haven't actually stood up for 2 years. We need to know that because then we need to be able to gently challenge them in the assessment, keeping in mind distress and things like that, but we do need to put that information to them to be able to then have a defensible capacity assessment. And always ask yourself, where is your bar for capacity? You might talk about this quite a lot. Is it too high, too low, about right? It changes, and each person's bar is going to be different as assessors and for the individuals as well. But we're linking in that person's circumstances, their relevant information. How much does that person need to know? It might be less, it might be more, but constantly that's about reflective practice, talking it through with your colleagues. Is my bar about right? Always base your assessments around case law and evidence. We've put in a lot of the relevant case law into our forms now. So you have those. We have that LBX versus K decision around what is the relevant information for care and accommodation. We now know about the fluctuating capacity case law. It's fine to cite it. It shows then that if the case does go down the Section 21A challenge route, that actually it shows the parties that you have considered that and you've grounded your assessments in the evidence, in the case law. And we have to reach a conclusion. It's not ever enough to say the person's capacity fluctuates, full stop. We have to reach a decision. Do they have capacity? Do they not for that decision? Are we granting a DOLS or not? And always, it's on the balance of probabilities. We just have to be reasonable, not right. Show your workings out. How have you reached your decision? And that's okay. And DOLS is a positive thing. It gives people that protective safety net. We talk about why we have DOLS. What's the purpose of them? Well, it's to ensure Article 5 compliance, that right to liberty. Everyone has that non-means tested legal aid. They can get their day in court if they so wish. And it gives people that mechanism to challenge. So if in doubt, I would much rather a DOLS is put in place than not. Because if it's not, and we say that they've got capacity and they're unhappy with their circumstances, where does that leave them? They've got no challenge, potentially, no way to sort of resolve that situation. They're reliant on themselves. So if you're on the fence and thinking, oh, I'm really not sure, I would rather that the conclusion is that we have a DOLS in place, because capacity evidence is about 90% of the time challenged in 21A challenges. As some of our doctors in the room will know, you get asked to do Section 49 reports and then look at capacity issues in more detail. But that it gives people that safety net. Remember why we're doing what we're doing. And just to finish on this, I went to a conference in London earlier this year, and Ben Troke was one of the speakers. People might recognise him as a partner from Waitman's. And he said, DOLS is a spotlight, not a padlock. We're not going in and locking people up. The managing authority has a care plan in place. They make their decisions about what the restrictions are in place. We're going in and we're casting a spotlight on those restrictions. Are they necessary? Are they proportionate? Are we, as the supervisory body, happy to agree that or not? We're going in as a checking system. We're not there to say, right, this is what's going to happen. You're locked up as a result of DOLS. So just remember that. We're a spotlight, not a padlock. Thank you. We've got about 5 minutes for questions before I pass over to ICSD. Does anyone have any burning questions? It's fine if you don't. It's really, really fine. I can go back and I can breathe now. Well, if anyone does, you know where we are. Dorset's MCA team and BCP colleagues, you have the same system. Talk to your DOLS teams, because it's better to have case discussions and peer supervisions and things. These are complex situations, so don't be afraid to ask. Thank you. I'm now going to hand over to Michelle and Ben, our special guests from ICSD, to talk you through about their role.
Thank you. You're right, this is a little bit intimidating. There's a lot of you. So I'm Ben Holt. I'm the team lead for ICSD in West Dorset, and it's my colleague Michelle Hughes who's the team lead for our East team. Does everybody know what ICSD is? Got some nods. Probably a lot of you do. Intensive Community Support for Dementia. Not everyone. So yeah, Intensive Community Support for Dementia. And I'll tell you a little bit about just a quick 10-minute presentation to show what we do, who we are, and what the purpose is. Can we have a next slide, please? So start off with a little bit of history about how we came apart. So as I'm sure a lot of you are aware, there used to be lots of beds, psychiatric beds to get people into hospital. Things were probably much easier then. In 2013, there was a restructuring of dementia services, and there was more than a 50% reduction in organic beds. So to help combat that, ICSD was set up, first of all, just with the East team, with Michelle's team over in the East. And we were kind of set up as a virtual ward with a purpose to try and avoid those admissions. There were less beds to get people into. And we were trying to look at a less restrictive option for people rather than going into hospitals. In 2016, that was expanded over in the West with my team. I've been there for about 6 months or so. But 2016, we were set up to cover West Dorset as well. So what we do is we provide an assessment and treatment, short-term intensive service for adults with dementia who are experiencing significant BPSDs, that's behavioural and psychological symptoms of dementia. And the purpose is to try and avoid, as I say, those hospital admissions. So where do we do this work? We kind of support people in their own homes, in residential nursing homes, in the hospital settings generally. And what we do is we support people, their families, their care staff, and try and resolve the crisis if we can, or actually provide evidence for why they do need a bed, and try and get them in. Can we have the next slide, please? So we operate 7 days a week, every day of the year. The East team at the moment are working full hours, which is 7:30 in the morning till 8 o'clock in the evening. At the moment in the West, we've been quite chronically short-staffed for a number of years, and we're working 9 to 5, but that's going to be changing very soon, we hope. When we get a referral, we'll assess within 24 hours. We'll go out and do a thorough assessment, a bit like in the presentation we had before. We're kind of looking at all those different elements of talking to the person, talking to the care staff, seeing what the evidence is and seeing what we need to do as far as a care plan. People will generally remain on our caseload for up to 6 to 8 weeks, often sooner. It depends on how long the crisis lasts for. And our teams are made up of qualified nurses, support workers, occupational therapists. In Michelle's case, we've got an ACP. The guys have got a doctor on the team and admin. So in the East, this is Michelle's team. They've got the area is probably smaller geographically, but larger in numbers. So it's kind of east, so Poole, Bournemouth, Wareham, that kind of side. So they've got 15.4 support workers, 8.6 nurses, nearly a full-time OT, a medic 3 days a week, an admin, and Michelle. And in the West, we've got just over 8 support workers, just over 6 qualified, an ACP instead of a doctor, who liaises with a doctor in the West, in the East for more support, and admin, and myself. So, our team vision, we aspire to make a positive difference to those living with dementia. We know that people going into a hospital bed isn't always the best option. It's really for holding risk, isn't it, hospital beds. People don't generally get better in a psychiatric unit. We put them there because it's the only way we can keep them safe, so we try and do that in the community. We look at less restrictive practices. Our staff have got lots of experience of working with people in dementia and trying to find what those triggers are, trying to identify what's making somebody agitated, why do they want to leave, what can we do about that, how can we manage that in the community rather than going into hospital. And really ultimately that helps them live a better life. Go to the next one. So access to a service, I'll pass over to Michelle. This better.
Thank you. So ICSD, obviously we provide intensive support to people, and our service is only accessed via the community mental health teams, or if people go into a general hospital via psych liaison or the dementia delirium teams. Unfortunately, we can't allow access from GPs or social services because the floodgates would open and we'd have too many referrals and we wouldn't be able to cope with that. So people need to have a primary diagnosis of dementia, or it needs to be recorded that there's a high chance that they're likely to have a diagnosis of dementia. They need to be known to the community mental health team, and they should have been seen within 24 hours of a referral to us. And the reason we ask for that is because sometimes you can get phone calls from people saying that they're in crisis, but actually when you go out and explore the situation a bit further, there are some other measures that could be put in place rather than intensive support. So we always ask for that to happen. And we're basically saying that people require intensive, which is daily support, and that needs to be agreed by either the person themselves or the family member, because sometimes we get referrals and you go out to do the assessment and the family are saying, yes, this is all very lovely, but actually we don't want you coming in every day. And if they don't want us coming in every day, there's not much point in us going out to do that assessment in the first place. And then again, obviously it talks about the psych liaison and home treatment teams, dementia delirium nurses in general hospitals, and also AMPs can refer to us. So if a Mental Health Act assessment has been called and it's felt that less restrictive measures haven't been looked at, we will take direct referrals from the AMP service and go out and either attend the Mental Health Act assessment or do our assessment before proceeding with the Mental Health Act assessment, so that we can look at other options that maybe haven't been considered. Next slide. So what do we help with? We do a lot of personal care assessments and role modelling approaches for care. Lots of referrals that come to us are around aggression on personal care in patients with dementia, and actually there's a lot of things that we can look at that may trigger somebody to be aggressive. So part of our work is to look at those assessments and look at what those triggers may be and provide education and support to carers that are maybe providing the care. And some of that is actually getting family members or carers to understand that you might not need a wash every day. Like, it's not essential to have a wash every day. Yes, I might like a shower every day, but this person with dementia may not. So it's looking at those things with people. We also look at assessments of functional skills. So we can look at road safety assessments, because some people are locking people in the house because they're worried that they might not be safe outside the house, and that increases aggressive behaviours. So actually we can do some of those assessments to look at where people are safe and where they're not. We can look at meal planning, shopping and support and access to the community. And our occupational therapist does a lot of those assessments with the patients that we look after. We look at behaviour management support plans. So again, we'll look at identifying triggers to particular behaviours, whether there's patterns, and try and look at whether kind of environment is playing a part in that, and see what we can change for that individual person. We only work till 8 o'clock in the evening, but I do have access to a budget, so sometimes we can pay for overnight support. So sometimes you get patients that aren't particularly sleeping, and we need to look at why that might be. And actually having somebody provide a night support into someone's home may actually reduce the need for them to be admitted into hospital inappropriately. We also look at kind of meaningful activities for people, and actually that being one way of reducing kind of increased aggression and behaviours. And that's particularly apparent in care homes. Care homes are meant to have all these lovely things that they do for people with dementia, but you go in every day and you see nothing happening. So again, we'll look at what sorts of activities may be appropriate for different people at the different stages of their dementia. Often we get people referred to us who may be living at home and may need to move into care, or may need to move between care homes. So again, we'll provide that support to ensure patients' needs are met whilst those longer term processes are being explored and identified for the person. And obviously part of our role is to review the pharmacological treatments, but that's at the bottom of the list, because actually there's a lot more you can do before considering just medication. Next slide. So these are the things that we do that are non-pharmacological. We are always looking at kind of whether patients are in pain or discomfort. whether there's some anxiety or fear in kind of what's happening. Particularly around personal care, there's this element of embarrassment, and actually having 2 or 3 carers come in to support you is not particularly dignified, and actually there's ways of managing particular situations. The understimulation and boredom is a massive trigger for lots of people, and sometimes loud and overstimulated environments can cause people to present with BPSD, so we're looking at all of those things. The basics around if a person's needs are being met, are they hungry or thirsty, are they needing the toilet, are they sleeping enough? Those very basic things that sometimes get overlooked, because if you've got somebody who's presenting as aggressive, all you're seeing is that behaviour, not all the other things behind that. Next slide, please. Then we're looking at the identified triggers. So we do a lot of observational visits. So we go out and spend time with the patient. We'll observe their behaviours. We'll document behaviours, we'll look at triggers, and it may be that we're in the home, a care home, for example, just observing a patient from a distance and looking at what's happening in their environment. And we can feed that back to say these are the things that are causing this particular person to become distressed. Sometimes distress can be increased after a family member's visited, and so we look at managing that with the care home around, can actually somebody from the care home spend some time with that patient to help them just whilst they're kind of going through that person's left again. Looking at the environment as a whole. Do people have to eat in the dining room? Are there alternative places? Very simple, basic things that just seem to get overlooked. And obviously, if somebody's presenting with behavioural problems, most people want them removed from that environment rather than looking at the bigger picture. And then obviously getting to know the person. So we try to use life diaries, this is me, because the more we know about people, again, the more that can help us to identify why they may be presenting with a particular problem. Next slide. So we try to work from the less restrictive principle, which isn't always easy. So we always try to not use the Mental Health Act as our first port of call, which is often what the referrals come to us for. People will phone up and say, we've got this patient, we think they probably need to be in hospital, can you go out and see them? So we will put things in place to try and reduce that need for a hospital bed. Doesn't always work, and then we know the next step is hospital admission. So it's just looking at what we can and can't do. We are a virtual ward, so we can technically provide the same level of support as what a ward environment can. You can get your medication reviewed, you can have nurses coming out up to 24 hours a day. So we're providing a ward environment in wherever is best for that person, and again, for people with dementia, that's better for them in the longer term. And we can provide periods of one-to-one, so some people might need one-to-one for short periods of time, and then that can gradually be reduced once we've worked out what their needs are and what their longer-term needs are. For example, we had a patient referred a few weeks ago. Her husband was dying. He wanted to die at home, but because of her dementia, she was interfering with her care, and the decision was being made whether she should be removed into hospital. In the end, he went into a hospice, and we provided her with 24-hour support at home. Within a week, she's down to 3 visits a day because we've managed to support her through that process. And again, trying to support someone at home until a care home is sourced is much better for them than moving them into hospital and then out to a care home. So it's trying to do what's better for the patient overall. Next slide. Challenges we face as a team. Family members of care homes are quite keen on hospital admission because it removes the problem from them. So sometimes you're going out and doing these assessments knowing that the end goal, what people want, is hospital admission, and they're very dissatisfied sometimes when we offer alternatives to that. Bed availability is a massive challenge, particularly at the moment. We don't have very many male beds, so we're always trying to look at, is there anything else we can do that doesn't require admission? And sometimes there is nothing else we can do, and we've had to place people in Portsmouth or Salisbury, so it's not ideal. There are rising numbers of patients being diagnosed with dementia, so there's increased support required. The caseload that we're having is constantly, the acuity is getting higher and higher, patients' needs are getting higher and higher, and risks are greater than they ever were before. I've worked in the service for over 10 years, and the patients that we see now are very different to what they were 10 years ago. It's really hard to recruit and fill the shifts. The NHS doesn't pay huge amounts of money, particularly for its support worker staff, and we're expecting them to work with some of the most highly challenging patients. And some of the difficulties with discharging patients or moving patients on is the lack of availability of social care. So I can complete my assessment maybe in 4 weeks and know that somebody requires a package of care 3 times a day, but that could take many more weeks to source. And obviously I can't just discharge a patient and put them back to square one, so they will remain on our caseload until that care is sourced. Next slide. We get lots of feedback, which is generally positive, and talks about people going the extra mile. I'm very lucky that we have a great team of support workers who always go that extra mile for people, and they're willing to do so much. And people are often saying that in the feedback they give. Next slide. Again, that's just some more feedback talking about kind of some of the things that we've done to help people. And we are lucky that most of the people in the team want to be in the team, and turnover of staff is low, which is particularly helpful. Next slide. Any questions? Yes. Yeah, so the diagnosis has to be dementia, but you can have other underlying health conditions. So we've had a number of referrals from learning disability services where people have maybe got to 40 and then started to develop dementia symptoms. So we've then picked up and provided support in those cases. And again, people with maybe schizophrenia, kind of as they're getting a bit older, they may then develop dementia. Again, we will pick up those cases and deal with those as they arise. Any other questions?
Okay. Thank you very much.
Thank you so much. That's all right. Thank you. So we're at a coffee break now, so we'll give you 20 minutes. So if we come back at 11 o'clock, help yourselves to tea and coffee and biscuits. Yes, we've got to sign in.
Over there. I did fill out the form as well.
Yeah, no, that's fine. Yeah, it's by the door.
I'll go over there.
Yeah, yeah.
Thanks.
Welcome. Thank you. Much experience.
Well, that was a very noisy coffee break, so I hope you got some networking done. So we've got 2 sessions now before we finish. I'm going to do a quick case law update. I've only got 3 bits of case law, so Tilly tells me I've got 45 minutes, and I can't sing, so I don't know how I'm going to fill 45 minutes. But I'm sure Jem will be happy to come on early. We might finish early. So there's not a huge amount like ground shaking happening in case law land, really. So the first case I've looked at is one it's really our stock and trade. So this is a 21A challenge, and I just thought it's just useful to kind of think about it. So it's a 90-year-old woman, diagnosis of dementia, residing in a care home. She's widowed, she's got 4 sons and a daughter. Some of her sons have got lasting power of attorney for health and welfare, and her daughter doesn't. There's a difference of opinion between the attorneys about her going home, so she very much wants to go home. Although she's actually settled in the care home, she doesn't like it. She says she wants to go home. She's very determined to go home. So this is stuff we see all the time, isn't it? So because the attorneys are not agreeing and she wants to go home, it's going to go to the court of protection. So we're in the court of protection. Have the next slide, Rhiannon. So the background, she'd been admitted to hospital in June 23 following a fall. Prior to that, she'd lived at home with a relatively small package of care. So she had 3 times a day, but they were of a short duration. She's a fiercely independent woman. She's got a long-term aversion to care homes and to social services. She doesn't like social workers. There's a surprise. But she's told her family that if she goes home, she won't need care. And when she was at home and she was receiving these 3 times a day care, she was quite resistant to it. So if she didn't like the carer, she wouldn't eat the food they prepared for her. She dismantled an orthopaedic chair, which I thought was great. I'm sure the OTs wouldn't have liked it, but that's quite feisty, isn't it? And she refused to use a riser recliner provided by her family. So she's one of these feisty ladies that we love so much. So from hospital, she was admitted to a care home. I don't know the story of that journey, how she got there, as so many of them just slide seamlessly into a care home, don't they? We have the next slide. So the reason I liked this is the judge brought us back to, do you remember Judge Eldergill talking about having a trial at home? And if you prejudge that it's not going to work out, it's not a trial. So just reminding us that it's okay for somebody to have a trial at home and for it to fail, because it's about a trial, it's about trying these things out. I guess the difficulty is always keeping the bed open, keeping the door open. And in this instance, they were able to keep the bed open for 2 weeks. So it was a 2-week window of a trial home. And the judge really said that if she had capacity, she would have chosen to live in her home of 64 years. And she'd been vocally resistant to the care home. Although actually, in the care home, she was receiving care and she was compliant with it. And actually, there was evidence she was kind of okay, really. So she had a trial at home. That was in her best interests and in accordance with her wishes and feelings. And as with all of these cases, we don't know what happened next. But I just thought that's just interesting for us, isn't it? It's our stock and trade. It's the work that you're doing all the time. Okay, Rhiannon's trying to make me dizzy here. My second case, this is a punch-up about beds. Quite glad ICSD aren't here right now. This is a 15-and-a-half-year-old girl who was subject to a care order, and she was a looked-after child. She had significant mental health history with difficulty in regulating her emotions, fluctuating moods, and suicidal ideation. She was currently an inpatient in a paediatric children's unit of a general hospital. Now, that was not registered to take detained patients, that particular unit. But the Acute Hospital Trust made the application for an order to allow the ward to deprive her of her liberty in the paediatric ward. Prior to that, she'd had a series of placements, of inpatient placements in adolescents beds, tier 4 beds, and in the community. She'd had also frequent admissions to General Hospital. So this young lass, quite a troubled young woman, but since March 24, she'd begun taking an overdoses of paracetamol. She was very determined in that. She was absolutely determined to try and kill herself. There'd been a massive deterioration in her mental health leading up to this, increased dysregulation, and she was much more determined to end her life. And the matter came before the court because she'd been trying to climb over a motorway bridge and she'd taken overdoses of paracetamol. And I know certainly in Dorset, we've had a couple of young women, very, very similar to this, very similar presentations. In this case, she was taken to an acute hospital where she was assessed under the Mental Health Act. She met the criteria for Section 2, so everybody's willing to sign the section papers. So an application was made to NHS England for a tier 4 bed, but there was no offer of said bed for her. And the rationale, if I could have the next slide, Rhiannon, that the consultant said that her needs could be understood as emotional crisis in the context of several stressors rather than due to severe mental illness. So they were saying that she didn't have a severe mental illness. They also were concerned that she'd had previous admissions to tier 4 beds. They hadn't been successful, and they were concerned about the contagion effect. So I presume by that they mean that she would pick up some other tips and hints from some of the other residents on the ward. And that, you know, that wouldn't be conducive to her recovery. Despite the acute trust agreeing that it would be counter-therapeutic for her to be admitted, they needed to prevent her from harming herself. So in real time, in real world time, we've got a young woman who is absolutely determined to kill herself. And they're really struggling. She's been absconding, and she really wanted to die. And we know that, you know, if you try often enough, it can happen, can't it? And actually, they felt that although the tier 4 bed might have been counter-therapeutic, it might have been that she would have picked up some hints and tips from some of her fellow patients, but actually it was the safest place for her, and that's why they were pushing for a tier 4 bed. The local authority had previously had her in a number of placements and hadn't been able to find anything suitable for her. And they were praised by the judge that they had actually tried very hard to find a suitable therapeutic placement for her, and they searched the whole country for that. And again, we've had a couple of young women in Dorset, and we know that finding those sorts of beds is really difficult for them. So the local authority's only offering would have been an Airbnb, which obviously wouldn't be designed as a therapeutic placement, and there would be a series of carers coming in to keep her safe. And again, we've had exactly that in Dorset, where I've got to see some of you nodding. We actually had a series of Airbnbs, because actually the young woman in our case damaged each Airbnb that she was in, and she progressed to damaging the Airbnb and the people around her. So it's not safe, it's not ideal, it's an imperfect situation. So the local authority, whilst if they were pushed into a corner, would offer, it was felt that that wouldn't be a safe place to keep her. So I can have the next slide. It was accepted by NHS England that she had a mental disorder within the meaning of the Mental Health Act, and that she probably had an emerging emotionally unstable personality disorder. So she would have met the criteria, but they were still holding firm that she couldn't have the bed. So the courts can't force NHS England to come up with a bed. Although we like to think the courts have got a lot of power, actually, as we know, they can only choose from the offers that are on the table. So they couldn't force the court to come up with a tier 4 bed. They didn't think that the local authority's offer of the Airbnbs was a reasonably safe option for her. So the judge also accepted that the tier 4 bed might be counter-therapeutic in terms of her kind of future functioning. But if we can go on to the next slide, Rhiannon, what the judge thought was that everybody was just missing the sort of blinding obvious that actually You can't really work therapeutically with a dead person. And actually, this young woman was on a track to kill herself. And actually, we've got an overwhelming responsibility to keep her alive. And if we can't do anything else, we just keep her alive until we can do something. So they felt very much that her Article 2 rights of the Human Rights Act were at risk and saw that as the overwhelming issue. So they ordered that she would be detained and deprived of her liberty in the general hospital, on the paediatric ward, sorry. But really criticised everybody and said that the state, and that's all of us, so that's the doctors, that's the hospital, it's the local authority, we collectively as the state have a duty to actually keep her alive, and she would much more likely, it's easier to keep her safe within a tier 4 bed, which is designed for that purpose. But nonetheless, the judge couldn't do anything about it, so deprived her of her liberty on the paediatric ward. So, again, I just thought it was interesting, and I think I've certainly over the last few months been buffing up against some of those scenarios with these complex people, often young people, lots of emerging, well, as Tilly said, cocktails of disabilities that are emerging. And there's no right place for them, but we've got to at least keep them safe. We've got to keep them alive, and we can regroup and try again another day. Any questions? Sadly familiar, I think, probably.
It's just a comment really, so obviously like the state have let her down, but they've let her down to that point already. Like
Yeah.
the family and the schools and the whatever for her to be in this position at 17.
Yeah.
So it's just a really sad story.
Yeah, it's tragic, isn't it? It's
Like
17 years old and she's already damaged young woman, isn't she? It's hard to see how she's going to pull back from that, isn't it? This is my final offering. So this is a follow-up on some case law that we've previously talked about in some of our forums. I don't know if you remember it, but it's the 19-year-old young woman who had a rare mitochondrial disorder. So she'd been cared for in ICU. She'd been in ICU, I think, on and off for 2 years, leading to this point. The trust were unable to, it wasn't a disorder that can be treated, so they were keeping her alive with various treatments. I think she was having dialysis and other treatments to keep her alive, but the trust felt that there was no likelihood of recovery, that the burden of those treatments was coming too great for her, and they wanted to move her to palliative care. And she didn't want to go to palliative care. She didn't accept that she was going to die. And I don't know if you remember the case, I thought it was really sad that she wanted to go to America or Canada for some experimental treatment. That offer wasn't on the table for her, so although in theory that might have been possible, that wasn't a genuine offer on the table for her, and she was probably too sick at that point to travel to get that treatment. But what she told the judge in the first instance was that she wanted to die trying to live. So, really sad. They made the declaration that she lacked capacity to give or withhold treatment, medical treatment, and that they could move her to palliative care. And whilst the hearing determined that it was in her best interest, she actually died 35 days after the original declaration. So, in the end, her care plan was agreed between her family, and the hospital. So, again, we don't know the details of that. But following her death, her parents sought notice to appeal the declaration of incapacity. So I guess they were struggling with the notion that she lacked capacity. So because the appeal was allowed, that she, about her lacking capacity, it was set aside, and therefore the presumption of capacity would stand, and we've got to kind of re-examine this. Now, I only read this yesterday. I've just come back off a week's holiday, so I haven't read all of the ins and outs, but if I can just go to the next slide, Rhiannon. The judge said that in the original case that she lacked capacity because she didn't believe the diagnosis, and she didn't believe that she was going to die, and she didn't believe what the doctors were saying. So they said, if you don't believe that information from your doctor, then you can't have capacity. So that... I mean, she was in a horrific situation. She didn't want to die. She was really young. She was terrified. And she'd been in ICU, and people around her had been dying over the course of a couple of years. I think she was so distressed that one of her family had to stay with her all the time. So she, you know, she was clinging on to a hope of life. But so that the second judge said that, although he was careful not to criticise the first judge, basically said that that's probably not okay to rely on that. I think it's okay to look at it, and I think it's very different to make an unwise capacitous decision. So what she definitely wasn't doing that. So she wasn't saying, I know what the options are, but I choose this option. So she wasn't it wasn't a capacitous decision. So they had to, the doctors at that case, at some point I think one of the doctors actually said that she had a delusional disorder because she didn't agree with the diagnosis. Yeah. Yeah, yeah. Yeah. And it's certainly within this appeal, it was looked at and it was considered. But if we can go on to the next slide, Rhiannon. So they said, obviously, the ordinary reading of the requirement of the section 3.1 and mental capacity, that the person must understand the information relevant to the decision about medical treatment. So that would include the consequences of having or not having the treatment. And if the person doesn't believe the relevant information is objectively true, then the person will proceed on the basis of incorrect information, so is therefore unable to make the decision for themselves. So that was what the original judge had kind of founded their judgment on. And I remember at the time, I think we were all a little bit, she didn't have a diagnosis, a psychiatric diagnosis. She didn't have a psychological diagnosis. She probably had some trauma because of the way she was living her life. So she would have had some trauma in there. And she didn't really have very many life experiences other than being really sick and in ICU. No. But if we just move on, actually what the judge felt was that the requirement for belief when a 19-year-old woman, she's fully conscious, suffering from no identifiable mental illness, no loss of brain functioning, with the support of her close family, refused to accept that death is imminent, but say loud and clear to two psychiatrists that she wants to die trying to live. I think the judge thought that was a very mature thing to say, actually. So they set aside that judgment. So the reason I'm just saying it is because I think for us, when we're assessing capacity, that's something that we're going to need to kind of tease out a little bit more carefully going forward. I mean, it was immaterial in this case, but I think from her family's point of view, I think that they felt they wanted that lack of capacity overruled, and it was. And the decision's not being appealed, so that will stand. I don't know if I've got a last slide or no, Rhiannon. Yeah, that was just the commentary, really. So an apparent lack of belief is what's being said is undoubtedly a legitimate reason to consider whether the person has capacity. So it's still there, but I think we need to tread a little bit more carefully than we might have done on the back of this judgment. So that's me done. I just thought that was an interesting, albeit a sad end to my little roundup of case law. I don't know if any of you's got any questions, or if not, I will pass you over to Gemma, who I know is dying to get up here. Okay. Well, no one else has had any notes, so I'm just going to try and wing it a little bit. So we're going to be talking really about equipment and technology-enabled care, and how some of those bits of equipment and technology-enabled care can sometimes impose additional restrictions and sometimes reduce those restrictions. So I'm not going to cover absolutely everything, but if you've got any questions, just raise your hands, or if you've got any discussion about any particular piece of equipment, then we can have a look at that as well. So I'm trying to keep it related to DOLS, but what we've had is a lot of DOLS assessors have picked up sometimes when maybe the most appropriate equipment isn't being used. So that's been really positive. We've managed to get some things really sorted for people who are in residential care due to DOLS assessors picking up, actually, is that appropriate? Actually, is that least restrictive? Is that in the person's best interest? So yes, quite exciting topic, but I shall go through and explain step by step. So next slide, please. So I didn't introduce, I'm Gemma Stokes, Principal OT from Dorset Council, but there we go. So I thought I'd try and do a bit of research. Is there any guidance in relation to equipment and deprivation of liberty? The main thing that I found was a good practice briefing on deprivation of liberty safeguards from the Royal College of OT. And they stated that equipment is required for care that has the potential to deprive a person of their liberty when it is used to restrict freedom of movement, for example, bed barrels, pressure mats, alarms, tilt and space chairs, and lap straps. A person can also be deprived of their liberty by withholding necessary equipment. And it was also recognised within that briefing that everyday furniture may also be used to limit an individual's movement. So, for example, a person who lacks capacity and is unable to push their chair back from a table. So someone could be sat down for a meal, and then if no one assists them to move, they could be sat there for 3 hours when actually that's not what they want to do. Okay, next slide, please. So I'm going to start with probably one of the first bits of equipment that comes to mind when you talk about restrictions is bed rails. So I was going to get people to talk in groups, but what is the purpose of a bed rail? That's one thing that we're going to think about today. So if you have think about what you think that is. Sorry, I did lots of little slide-ins. And what are the risks that might be posed by bed rails? I think sometimes care homes will quite willingly put in bed rails, whereas actually there's quite a few risks associated with bed rails. And what is the relevant information that needs to be considered to make an informed decision? I think most of the people we come into contact with DOLS probably lack capacity in relation to their care needs, and actually it's what is that relevant information that then needs to be used to make a best interest decision on behalf of that person. Okay, so we'll start with the purpose. So the purpose of bed rails are to prevent or reduce the risk of bed occupants falling and sustaining injury. They're not designed or intended to limit the freedom of people by preventing them from intentionally leaving their beds. And they're also not intended to restrain people whose condition disposes, I can't read now, I'm getting a bit close, I need to get a bit old now, whose condition disposes them to erratic, repetitive or violent movement. And the use of bed rails in the above ways can increase the risk of falling or injury. So to prevent inappropriate or unintended restraint through the use of bed rails, there must be a robust risk assessment of whether the use of bed rails will prevent the person from moving freely or make the person feel restricted from moving freely. And in all cases, the least restrictive options should be explored. So I think when you're doing your DOLS assessments, you can quite often come across that someone's got bed rails, and actually part of that will be having a look at that risk assessment that's been done to make sure that what options have been considered, who's been consulted, actually is the provision of bed rails in this in this best interest of the person. Okay, so I thought we'd just have a quick look at some of the risks. So the MHRA, anyone know what MHRA stands for? I shall have to look at my notes, but it's the Medicines and Healthcare Products Regulatory Agency. So they're responsible for medical equipment that is used.
So they continue to receive reports of deaths and serious injuries from entrapment or falls relating to medical beds, bed rails, trolleys, bariatric beds, lateral turning devices, and bed grab handles and bed levers. So it's important to realise as well that bed levers sometimes comes into this because they're small bits of equipment that you'll often see, but they can actually cause quite serious injuries. And so from the 1st of January 2018 to the 31st of December 2022, there were 18 reports of deaths related to bed rails and associated equipment and 54 reports of serious injuries. So I just go into it. The deaths were found to involve the following factors: inadequate risk assessment, maintenance issues of equipment, children or adults of small stature using beds designed for use by adults with typical body dimensions, inappropriate use, incompatibility of products, and the person's physical or clinical condition. So this prompted the MHRA to have a national patient safety alert. This was in August 2023. And so what we've now got to do is to make sure there's a documented and up-to-date risk assessment for any bed rails or bed grab handles that are in place. So again, when you're out doing DOLS assessments, is there a risk assessment? Has it been reviewed? Because that's the other part, is saying that risk assessment should be updated where the equipment or the patient's clinical condition has changed. And that could be a reduction, improvement in weight or mobility, or a change in cognitive ability as well. And they should also be reviewed at regular intervals. Okay, so still talking about risks here. So the adverse incident investigations have shown that the following issues place someone at increased risk of entrapment: communication problems, confusion, agitation or delirium, learning disabilities, dementia, repetitive or involuntary movements, large or smaller than average body size, impaired or restricted mobility, and variable levels of consciousness. So I think looking at all of those, they're probably quite common themes that you'll find when you're doing your DOLS assessment. So just a little bit about some of the information to be considered. So the first thing really is the person at risk of falling out of bed? What's the evidence of that? Have they fallen out of bed before? Have they had near misses? So sometimes families or care homes want people to be safe, so assume that bed rails will prevent them falling out of bed, whereas actually there's no identification of any risk that they might fall out of bed. And also, is the person able to get out of bed independently? If they are, then we're probably not recommending bed rails, unless the person's got full capacity and wants the bed rails there and knows that they won't be able to get out until the bed rails are lowered. Is the person confused enough or mobile enough to try and climb over the bed rails? So again, if they are confused and not knowing why they're there, then we could have an increase in injury risk because they're then climbing over the top and falling from a bigger height than they would have done if they weren't there. So it's also recognising that every effort should be made to explain to the person being cared for why bed rails might be needed, and obviously to also explain the potential risks. So again, when we're looking at making decisions, actually, yes, bed rails can stop you falling out of bed, but there might be some other associated entrapment risks that could pose injury to that person. And it also recommends that the decision to use bed rails should be made with the person's consent wherever possible, remembering that they may have a different perception of risk to the prescriber and therefore disagree on whether the risks are acceptable or not. The reasoning for the decisions to prescribe rails should be effectively communicated and recorded, including the carers or families members' views. So again, when you're looking at the risk assessment, what's been considered, who's been consulted, and actually what is the best outcome decision for that. And again, so if we come to the conclusion that actually bed rails are going to be used, then we also need to consider how is the person's needs going to be anticipated when the bed rails are up. They can be quite restrictive bed rails, it restricts your views. Has the person got a method of contacting a carer if they wanted to? Is a bed lever needed in addition to bed rails? If so, that will need to be part of the risk assessment and recorded. try and consider what type of bed rails are the least restrictive. So there are different ones. There are metal bed rails that you can have bumpers on. There are also mesh bed rails. So mesh bed rails might be less restrictive because someone can actually see out and might feel less claustrophobic. But again, remembering if using mesh bedside rails, there should be wedges to fill the gap between the rail and mattresses. So when you're doing your assessments and you see someone who've got bed rails up, just check there's not any gaps, or something doesn't look quite right with the bed rails. Have they got the bumpers on? Are they up? And again, are standard bumpers required to reduce the risk of entrapment? If they are, standard bumpers can also cause a risk of suffocation. So again, if someone has got those on, what's the risk of them suffocating if they don't understand to not roll into them and then obviously have problems? And again, you've got bed rails fitted. When are they to be used? You might not need them up the whole time. So again, is that part of the care plan? So another consideration when doing your risk assessment for bed rails is, are there any alternatives to bed rails? And I was going to get you all to think of some lovely alternatives to bed rails. I'm sure you all think there are. So here are a few. It's not an unlimited list, but it might be different environmental measures. You might have a different room layout or make adjustments to the room. There might be falls management strategies to reduce the need for bed rails. You could use a lower bed height to reduce the risk of injury. You could use an ultra-low height bed to minimise the risk of falls or injuries. You could also use alarm systems or tech to alert carers when someone's wanting to get out of bed. You could review medication, use of body positioning wedges or sleep system, or you could tuck someone's sheets in, again, or use of a high impact absorbing falls mat. So having a look at those alternatives, it's also considering actually, are they any less restrictive than some of the bed rails? Because I think some of those options, lowering the bed height, are still going to make it hard for people to get out of bed, aren't they? So actually, it might reduce the risk of entrapment, but actually there's still going to place a restriction on that person to get out of bed if they want to.
I swear it says environmental measures. I know a lot of care can wedge your bed up against the wall. What's your...
Well, there is a little video to come, and you will see a little example of that. So yes, there's also a risk of entrapment as well. If you're wedging a bed up against the wall, I don't know if you've all done it, if you've a single bed and sleep next to the wall, sometimes your arm or your legs will get trapped between the wall and the bed. So there will be a little video motion. So yes, there's also a risk of entrapment by doing that as well. So it's not good enough to say, actually, we're just going to put the bed against the wall. So again, that's good. It's good that that's being picked up, because that might pose an issue, and these can result in some really sort of serious injuries and even deaths. So I think it is worth considering that. In some cases, it might be better to have a bed with correctly fitted bed rails than a bed pushed up against a wall. Okay, I'm not sure. Oh, we have got the video next, so hopefully the sound doesn't come up. If the sound does come up, it's terrible. But this is from Kirklees Council, so just giving a quick... just a summary of what we've just spoken about, really. Luckily, it's not, it's not one of our customers, so that's fine. I'm glad the music hasn't come on. It's really terrible music that they play with it. So again, that's a bed lever, isn't it? And you're using the profiling bed, that arm is going to get completely squished. That's demonstrating the gap that you can have. That's the wall and the bed situation. And again, sometimes you might see that. You might see people using those bed rails to pull up. Actually, that's going to cause the bed rails probably to get loose and not be fitted correctly. And again, if you've seen a higher mattress been put on quite often by some nursing staff, actually have they done extra high bed rails to prevent that person coming over the top? Oh, he's still going. Reminds me of Harry Hill. I don't know why. But anyway. And this is how we talk about some of the alternatives. Actually, are they less restrictive? That's going to be quite unstable if he does manage to get up as well. Okay, so that's it. Although it's not the best video, but actually it does demonstrate most of those risks in a bit more of a pictorial way. So I think that's probably the bit on bed rails. So has anyone got any questions so far in relation to bed rails? No? And it is a care home's responsibility. They are responsible for doing that risk assessment and putting that in place. And I think sometimes, as we spoke before about Dole's assessment, you're a bit of a spotlight. Actually, have they done what they're supposed to be doing? And there is obviously a requirement from the MHRA as well to make sure that care homes and different organisations such as ROTs all have the most relevant training to be able to issue bed rails, and to obviously make checks on these as well to make sure that the bed rails are fitted correctly as well. So the next thing I thought I'd have a quick talk about really was about when people are cared for in bed or bedbound. I've seen that quite a few times come back on some of the Dole's forms when I've been acting as signatory. It's like they're bedbound. Why is that? It's quite a big restriction, isn't it, being limited to your bed and not being able to get out. Okay, so we've got the examples of someone being cared for in bed. So as I've just said, it's very restrictive, and there would need to be a really robust support plan about why that is the preferred option and why it's in someone's best interests. So a care home not having suitable seating is not a good enough reason for someone to remain in bed. What has been tried or explored to sit the person out of bed, and why was that not successful? What therapy reports are there to support that this is the only option or most suitable option? And for who? Sometimes it's a more convenient option for the care home, but actually we should be concentrating on what is the best for that person. And if they are remaining in bed, what postural management plan is in place to prevent contractures? And if the person does not want to get out of bed, why is that? Quite often I've read things, the person doesn't want to get out of bed. I'm like, really? Is that really true? Actually, what have we done to explore why that person doesn't want to get out of bed? There's nothing going on. There might not be a reason to get out of bed. So again, this comes back to a key part that OTs love to look at, is that activity. What does that person want to do? How are they going to do it? And again, when you're cared for in bed, you're going to be limited to what you can actually do. Yep, and that's what I've just said about sort of engaging in those activities. So I thought just outline some of the health implications that can arise from remaining in bed. So I have got a link there, which you should get the presentation. So there is another lovely video if you want to watch. If we had more time, I could probably get you to watch that. But again, just a video about contractures. So that's really important. And care homes should have access to that. So they should be using that as part of their training. And also on the slide as well, there's a 7-minute learning in relation to contractures. So obviously staying in bed, you get a loss of muscle strength and endurance, and also reduced sitting balance. You can have cardiovascular issues, increased heart rate, decreased cardiac reserve. Also makes you more susceptible to pneumonia and respiratory tract infections and urinary tract infections, pressure sores, blood clots, and constipation. If you're in one position, it doesn't really help the fluids and bodily functions to actually work appropriately. And so I thought also it's not just about the health issues. If you're restricted, you've got quite a lot of social restrictions, haven't you? If you're stuck in bed, you've got increased isolation, probably a higher risk of becoming depressed, make people feel helpless. You've got inability to access the rest of the property. So if you're in a care home that's got some wonderful facilities, but you're stuck in one room, what are you paying for? Unable to participate in community activities or usual interests. Again, you know, if the person is remaining in bed and there's a valid reason for that, how can we encourage those activities to be taking place within the bed? You might get reduced motivation to eat, because quite often there's quite a social event, isn't it, having your meals? But actually, if you're in your bedroom on your own, you can't sit up properly to eat your meals. Actually, it might increase your likelihood of becoming malnourished. So again, you've got loss of power and control, loss of dignity. Again, if you're not getting out of bed, you know, how is your personal care being managed? And again, reduced quality of life. So really, we should be not accepting that someone is bedbound, or at least within your assessments, having a look at why is that? Actually, what evidence is there? What's been explored? Why are they in bed? And I've had a few examples myself as a signatory, and obviously when I've done Dole's assessments, you know, you've got it there, and you look at it and you're like, oh, they were walking in the hospital site. So what's happened? They've come into the care home and they're worried they're going to fall, so they're not getting out of bed. You're like, okay, how long has that been? Because the longer obviously someone is in bed and not mobilising, their function is going to decrease, and it's likely that they might never get back to that mobilising. So I think it's really important to look back and if you're thinking, well, actually they were walking there, they were transferring there, they were mobilising with the assistance of one or two, actually that's when you might put in some of your suggestions. Actually, can you get a physio to go and have a look? Let's see if we can get them back mobilising again. Okay, so any questions on remaining in bed? I think it's quite self-explanatory that we should be looking at all the other options. So the next thing, just sort of have a quick talk about, is wheelchairs and seating. So quite recently, I was made aware of a case example where the only seating available to the resident was a standard manual wheelchair with no postural support. And this lady could only tolerate sitting out in that wheelchair for 3 hours a day. And she had very poor trunk control, and actually her posture was getting worse because she could not tolerate that. So what did she do the rest of the time? She was put in bed. So it's like looking at that question, and it came to OTs to look at that assessment for a chair, but this person had been in the care home for a year. I think, why has she only had access to a wheelchair to sit out in for 3 hours a day? And that's when you're considering, look at what seating options does that home have. So when a care home says they can meet someone's needs, they should be providing the relevant equipment to meet those needs. It's not, we'll meet your needs, but actually we've got no chair or bed that's suitable for you to sleep in or sit in. So yeah, look at what seating options a home has, and what is the reason for the person not using those options that are there. If none of the seating that is there is suitable, what options have the home considered? Have they requested an assessment? Have they tried any other chairs? And if remaining in a wheelchair all day, what's the care plan around that? And what assessments have been undertaken? So wheelchairs really are a mobility aid rather than a seat. So again, people might want to sit comfortably even though they use a wheelchair. And again, I think one of the probably the examples of restrictions that you've probably heard about is tilting space chairs as well. They completely have their purpose, but if someone is able to mobilise, you probably wouldn't be sitting them in a tilting space chair because that's preventing them from getting out. Okay, so here's some other questions to think about when you're doing your assessments. So again, other ways that restrictions can be imposed. So is if someone requires equipment to mobilise, have they got access to it? I don't know, I've been into care homes a few times where someone's mobilised to their seat and then their walking aid is just put at the other side of the room. It's like, if they want to get up, what's going to happen? Are the carers there watching to see if they're making attempts to get up, or are they just going to sit there because they don't feel safe to get up because they haven't got their walking aid? Again, we briefly touched on that about tables preventing a person from getting up. That could be a standard table, or it could be an over chair table that's positioned there, which which someone might be able to move, but actually sometimes cognitively wise, if you've got something in front of you, you're not going to try and get up. And again, looking at that lack of ability to call for assistance, to actually, to say that you want to move. If you're left there and you're observing, where are the carers? Are there carers around that will assist that person if they want to get up, or is that person shouting for ages and gets no response? Another area that crops up with OTs quite a bit are lap belts and harnesses. So again, it's thinking about the purpose of those lap belts and harnesses. They are not to prevent the person from getting up out of the chair. They are to prevent people from slipping or falling out. But again, you should be able to find somewhere in the notes a nice risk assessment as to why that has been selected and the purpose of it. And so another area that I'm just going to cover is technology-enabled care, often just called tech. So it's good when you're doing your assessments just to have a look about what current tech is used by the home, and is that the least restrictive option. So I think I've had an example recently as a signatory, and had three assessments to look at, and they were all from the same care home, and they all had bed rails and a PIR movement detector. It's like, oh, okay, 3 of them, have they all got exactly the same needs? Is it all the same risk assessment? And it was interesting. So it's, again, just piquing your professional curiosity about why is that? There might be a valid reason to have both, but is it quite restrictive to have both? If someone's got bed rails, you wouldn't expect them to be moving. Is it? Hopefully the PIR detect's not there to detect if they're climbing over the bed rails, because they shouldn't be in place. So again, it's just thinking, isn't it? And when you see care plans that look very much the same for the residents that might actually have quite different needs, then it's just having a look and say, okay, where's the risk assessment? Where's the best interest decision? And how has that been made? So again, yeah, I spent ages just sort of going back, and I think I had to go back just to get some more information. So what was the reason needed for the movement detector if the person had bed rails? And again, just considering, was that the least restrictive approach? And can tech provide a less restrictive option to current restrictions? So we get this quite a bit, don't we? Requests for one-to-ones, or someone who's got one-to-one support. So how could tech possibly, just sort of thinking, how could tech be used to reduce the need for that one-to-one? So I think to start, your starting point with that one-to-one is actually what is the purpose of that one-to-one support? And then you can always seek advice to see if there is any tech. There might be some more non-standard tech that we might be able to use. But again, it's, yeah, what is that purpose of that one-to-one? What is it trying to achieve? So again, could one-to-one be reduced by tech to alert carers if someone's moving from room to room? Sometimes there's one-to-one because people might get themselves into a bit of difficulty if they're going into other people's rooms. Actually, can you allow that person a bit of freedom and then just alert carers if they're going into a room that they shouldn't be going into? Could tech be used to prevent the need for one-to-one supportive access in the community? So I think we've had a recent So I think traditionally, obviously, equipment's come a long way, I think, in the last 20 or 30 years, hasn't it? So what we've got now is a lot more modular seating, modular equipment that can be used to meet different people's needs within a care home. So if we provide equipment, it's for one person and it's for that person to use, whereas care homes can get equipment that is adjustable and can be used for a variety of different people, even, you know, more than one person during the day if you adjust it and then give it to the other person. So we should be looking at that, and that's what we're saying now, is actually bespoke equipment for us would be something that care home really wouldn't use for some of their other residents. So it's looking at that situation, is how likely is that care home to be able to use that equipment with other residents. So, you know, if it was more of a specialist or bespoke piece of equipment that actually that care home are likely never to use again, then we would look at provision. But I think the best option is, okay, yes, OTs can do an assessment. The care home should be obviously have some assessment as well about what they've tried. So it's not good enough to say, well, we've got no chairs. It's like, well, why haven't you got any chairs? So again, it's looking at that. The OTs can help assess, and then we will look at actually, is it a contractual issue that that the care home aren't providing the equipment they should be? Have they, you know, we also often have discussions with safeguarding, I think Peter spoke about equipment, you know, and it's just, you know, has that care home been aware and neglected the need to actually find out what equipment should be done? Then it might go down the safeguarding route, but I think usually quality and monitoring, actually, is that care home meeting the contractual agreements that's written in your letter of agreement, you know. We're trying to tie down a little bit, actually, when you're placing someone in a care home, let's have it on the table to start with. What equipment have you got then to meet those needs? You say you can meet those needs. What equipment have you got? And quite often we'll have people, we can meet the needs, but we need a bariatric bed and a chair. It's like, well, if you're saying you can meet the needs, how is that? So I don't think it's ever a debate that's going to be completely resolved. We have guidance, of course, that's not law. So again, it will be looking at what is the best thing for that person. And of course, we don't want any safeguarding issues. So we will provide equipment temporarily if it's needed until the care home should purchase. But always be wary when they're charging people extra, because you're paying how much per week already? What does that include? You know, they should be doing that, and I think the more we can challenge care homes, the better it's likely to be. Care homes can actually purchase some really cost-effective equipment that will meet the majority of their needs of their residents. But sometimes I've seen people spend lovely space in the outside garden, but no one can get outside to use it. Actually, they should be spending that money on that really vital equipment and seating that people need. Yeah, and I think it's good. It's just good to recognise those, you know. And again, when you bring it back to the dolls, if you're noticing that, actually make the questions then: how are you going to meet the needs when this continues to deteriorate? But you're right. We need to look at what is best for that person. So you know, if that home, sometimes you have homes, don't they, saying actually they've gone beyond what we would normally cater for. In those instances, we might say, well, we'll provide. If you're happy to keep them, we can provide the equipment, because you wouldn't normally be using that, and actually, you know, that person will stay there. But we really just need to make sure that the right piece of equipment is in there, and actually that's being considered when we're placing people. Yeah, someone shouldn't be disadvantaged because they're in a care home. You should still have access to the correct equipment, but you know we are paying a fee for a care home to meet that person's needs, and when you're paying quite a lot, so we would be expecting nursing homes to have a wider range of equipment as standard within their home than a residential care home. So it's again, what is that statement of purpose of that residential care home? What client groups is it saying it can meet the needs of? And that's where you have a bit of a challenge. Well, you say you can meet the needs of people that are non-weight bearing. People that are non-weight bearing won't have good trunk control. They're not going to be able to sit in a bucket chair that you see in care homes as the standard furniture when you go in. So it's always worth questioning that and actually getting that referral to OT to highlight some of the needs actually as early as we can, so that we can get these instances resolved, rather than OTs being called in after that person's just not had the right seating for 2 years, because quite often they've developed contractures, their mobility is even worse than it would have been. I can see Peter. Yeah. Yeah, thanks. Like I say, it's really great, isn't it? We've got eyes and ears out there, and especially as Doles assessors, you will pick up these things. So actually, it's good. Raise it. Put that as one of the recommendations. To have a referral to, some of the health staff. And again, for me as well, quite often when you're looking at some of these cases coming through where people have got contractures, you find that they've got health staff in there. Why has this not been picked up? And I think within the slides as well, you've got the link to the video. There's the 7-minute learning. That's all absolutely fine to readily share with people, so there's no problem. You can always share the links with the care homes as well. Just check that they've got their staff trained appropriately, so we're not in these situations where you've got large scale inquiries. And again, if you notice that one person hasn't got the right equipment, actually what's going to be the state of the other residents? So sometimes it's really useful just to pick up that issue so that we can actually resolve things before it gets to the stage where it's gone too far and people have got really severe contractures, and it's then really, really difficult. And we are looking at bespoke seating to get people sat out because of the limited range of movement they've got left.
In terms of thinking about conditions that we might put in place, are we saying to the care home that they need to make a referral to OT, or do we? And how do we make a referral to OT? Social care or?
Yeah, it could be through health or adult social care. So it would be a recommendation that home obviously would seek an assessment. If you've picked up that actually that person's starting to get contractures, then actually a referral through to the health team to start with would be key. So the community rehab teams or whoever, from a health perspective, care home will do that. Yes, they should know how to do that. If they don't, then we should be seriously concerned. But quite often care homes as well, they will have district nurses coming in. District nurses are trained in contractures. So sometimes, again, it's why is that not being picked up? Health can refer to health. And again, district nurses that give advice on contractures as well. It's not just an OT or a physio thing. It's actually everyone's awareness. And I think with contractures, it's looking at, isn't it? If you haven't got the right equipment or seating to sit out, if you're in bed, people tend to lie in a fetal position, and that's where they get stuck. So again, I would be saying actually we can probably stop contractures if you're picking up that someone's bedbound. No one really should be bedbound. There might be some reasons why people remain in bed to deal with pressure ulcers, or there might be lots of reasons why they can't get out of bed because of pain, but we should have tried to consider everything. And then if we can't get that person out of bed, then there should be that postural management plan. So again, care homes should be referring to community rehab teams for that postural management plan, and they will have one. And then it's, again, if there's a postural management plan, when you're going out doing your assessment, is there evidence that it's being utilised? Is there that positioning? And we're not saying care homes don't have to have these amazing postural bits of kit. Actually, cushions, pillows can be used just to change someone's posture, or it's that regular change in movement that people need rather than being left for hours in one position. That's a good question. Again, it's looking at that purpose of that care home as well. So if a care home says that they meet the needs of people with dementia, you would expect them to have some access to some tech as standard. But again, it usually comes in. From Dorset's side of things, we've got a tech OT team, which obviously will be able to assist, make recommendations, and then we usually have that debate about actually, would you expect that particular home to provide that equipment as standard, or is this something slightly different? And a few occasions we thought actually it's not really run of the mill. You wouldn't expect them to have a standard supply of that equipment for all their residents, so we will provide equipment in those cases. It's really not a black and white decision about whether you provide equipment or tech or not, so it's very woolly, the legislation around it, so it's always worth just exploring and unpicking some of that. But the key is we need to get the right equipment in place as quickly as we can for that person who we have been involved with or that we're aware of. Any other questions? I don't want to open a can of worms, but we have got new Pan Dorset guidance about the equipment into care homes, which is much more robust than it used to be. So it's always worth knowing that that document is there and referring care homes back to it. And if not, then that will be conversations that we're having with quality and monitoring to go back to the care homes and say, actually, you've said that you can meet this person's needs. That includes equipment. How are we going to resolve this situation? Okay, thank you for your time.
Thank you, Gemma. And can I also say thank you to Tilly for her presentation. And thank you for Jason for recording it, hopefully. And to the MCA admin team who have doubled up as dinner ladies, tea ladies today. So thank you as well.